Welcome back to IBIL. There may be one or two of you who've never been here before, but none of you who are here now will not come again, I hope. All I've got to do this evening is to thank Richard Arnold for chairing it, and most especially for our two distinguished visitors for coming all the way to IBIL. I'll hand over to Richard.
Of course, we've had the World Wide Web since 1994. You might have thought that 18 years in we would have some idea how trademark law applied to it, and yet there still seems to be a great deal of uncertainty. Of course, in Europe, if you're faced with a problem about trademarks on the internet, you have to be considering at least 3 different pieces of legislation. You've got the Trademarks Directive or the CTM regulation if it's a CTM. You've got the E-commerce Directive, and you've got the Enforcement Directive. But of course, even that won't be enough, because as we know, a lot of the problems that crop up on the internet involve problems of accessory liability, where, of course, we have no European harmonisation, and so you're thrown back upon the national laws. There are, of course, plenty of situations where even that lot isn't enough, and we have to start looking at things like the Comparative Advertising Directive. So we have a fairly complicated legal terrain, and it doesn't cease to be the subject of debate and uncertainty. Moreover, of course, we have both similarities and differences from that other great topic of legal uncertainty currently, which is copyright in the internet. Now, to help us understand these questions a little better, as Robin has said, we've got 2 eminent and distinguished speakers who are going to give us views firstly from the US and then from continental Europe. And to begin with, we have Professor Barton Beebe from NYU. He's had a distinguished career, having taught previously at Cardozo and elsewhere, and is the author of a number of distinguished articles on the subject of both trademark and copyright law. So I'll hand over to him.
Thanks very much. I'm just delighted to be here. I must admit that it's quite humbling to appear on the stage with Mr. Justice Arnold and Dr. von Muhlendahl, and to have been invited to this event by Sir Robin. I also had the pleasure of looking at the attendance list, which is also just extraordinarily humbling as well, talking to this kind of body about issues that I think in some cases some people in the room might know more about than I do. But in any event, I'm delighted to be here. I think this might be the most glamorous trademark law event I've been to in my brief career. As a preliminary matter, I'll confess that I have no PowerPoint presentation, and as an American academic, I'm not exactly sure what to do without such a thing. But I was repeatedly assured, in fact even encouraged in this regard, that you will not feel slighted by my lack of multimedia swipe transitions and blinking text and the rest. But I haven't come completely empty-handed. Through the course of my brief talk, I'll be mentioning a variety of U.S. federal court cases and Google policies with which you are probably already familiar, but in any event, I've posted on my website, bartonbeebe.com, a PDF that gives you a citation list of all the cases I'm mentioning in this talk. So in the next 25 minutes, I plan to focus on 2 important controversies in recent U.S. law that implicate the relation between U.S. trademark law and the internet. These are, as you might imagine, first, the Tiffany v. eBay case, which culminated in an April 2010 Second Circuit opinion. Tiffany involved, among other things, what will be a familiar question to you, quite likely. The question of whether the well-known auction site eBay should be held indirectly liable for others' sale of counterfeit goods on the site. And second, Rosetta Stone v. Google, which is a slightly less well-known case, but still probably known to at least a few in the room. This case is still ongoing in the Fourth Circuit in the US. We had oral arguments in the case last September, and we are eagerly awaiting an opinion. I checked a few hours ago to see if one had been issued this morning. No luck. Rosetta Stone involves another question that will be familiar to you. The question of whether Google should be held liable for trademark infringement by virtue of its AdWords program, a program which serves sponsored links that are key to certain trademark search terms, and that in some cases contain those very search terms in the text of the sponsored link. If there is time, I'll also address a few other areas of interest, such as credit card provider liability and the recent spate of legislative proposals that have emerged out of the US Congress lately and all died, as they tend to do or have tended to do over the past few years. Of course, all of these issues have also emerged in the European context, most notably for Justice Arnold and Mr. Justice Arnold in a variety of guises. But I will, for the most part, forbear from commenting on the great, gorgeous kaleidoscope of European case law on these issues, because Dr. von Muhlendahl is much more qualified to do so in his 25 minutes, and I wish him luck in that regard. By comparison, you know, I should start. The U.S. case law, I think, is quite simple. I actually don't have much interesting to say, I'm embarrassed to admit. I'm here basically giving you sort of kindergarten level stuff compared to the European context, where I must admit I find it absolutely mystifying, much of the European case law. I think you might find the American approach is much simpler, and I say that in the sense that it's simpler for better and for worse, of course. So first, let's talk about Tiffany v. eBay. There is much of great interest in this case, and I hope you will permit me a brief one-paragraph digression in this regard. Part of my work in intellectual property law takes inspiration from British cultural studies, which still has some influence in the US, at least in certain parts of US thinking. And in this vein, the Tiffany case strikes me as just one among many recent examples of a new social role that we are calling upon intellectual property law to perform. This new role was once performed in early modern societies by sumptuary law. We can no longer rely on nature to enforce rarity. Everything, even diamonds, can be persuasively copied. And as both Mr. Justice Arnold noted in L'Oreal and the Southern District of New York Judge Sullivan noted in his district court opinion in Tiffany, the plaintiff's experts in both cases struggled mightily to distinguish counterfeit from authentic goods. And Tiffany, if you haven't yet tasted the Kool-Aid, is a high-end jeweler based in New York and a very successful jeweler in the US. And so we rely on intellectual property law to do the work that nature once did. We rely on the intangible, as does the De Beers cartel with its new forever mark, to do the work that the material once did, and thus to sustain our system of consumption-based social distinction, a system of invidious distinction, to refer to the American thinker Thorstein Veblen. I put it to you, I'm almost done with this digression, that there is little in these intellectual property cases of incentives to innovate. Why should there be? These are trademark cases, you might say, or even of moral rights, and only a bit of real consumer confusion as to source, typically in the post-sale context where those who are confused couldn't afford to buy the authentics anyway. These are no doubt familiar, even hackneyed observations to you. I hear them from my students all the time. I don't consider them hackneyed when I hear them from my students. I consider them very revealing of the true state of trademark law, not just in the US, but around the world. Companies like Tiffany and L'Oreal and De Beers are calling on our courts to serve as sumptuary police, all to prevent, as one English court put it in paraphrasing a party's argument, the effrontery of, quote, chavs hanging about outside McDonald's smelling of fine fragrances, unquote. It all seems a strange expenditure of judicial resources. But this is a topic for another day, quite clearly. Our concern here is much more basic and much more realistic. It is to consider whether the Second Circuit got it right in Tiffany, got it right as a matter of law, as a matter of efficiency, if you like, or even as a matter of fairness. And in any event, what the continuing implications, if any, of the Tiffany decision are. So first, some background about this Tiffany case. Tiffany's appeal of District Court Judge Sullivan's extensive, gorgeous bench trial opinion, very detailed bench trial opinion of July 2008, presented the Second Circuit with two main issues to decide. First, and of strangely lesser importance in the grand scheme of the Tiffany case, first, did eBay engage in direct trademark infringement when it purchased on various search engines sponsored link advertisements keyed to the search term Tiffany? Relatedly, did eBay engage in direct infringement when it used on the eBay website itself the term Tiffany to refer to Tiffany branded goods? The second issue, the main event in the case I'll get to in a moment, on indirect liability. Judge Sachs' opinion for the Second Circuit, joined by Judges Parker and Goldberg, made quick work of these questions of direct infringement. Judge Sachs was unwilling fully to embrace the doctrine of what most of us in the US call nominative fair use, a judge-made doctrine first developed in the Ninth Circuit by Judge Kaczynski. Instead, Judge Sachs simply explained that, quote, we have recognized that a defendant may lawfully use a plaintiff's trademark where doing so is necessary to describe the plaintiff's product and does not imply a false affiliation or endorsement by the plaintiff of the defendant, end of quote. In light of that standard, Judge Sachs agreed with the district court's finding that, quote, eBay used the mark to describe accurately the genuine Tiffany goods offered for sale on its website, and none of eBay's uses of the mark suggested that Tiffany affiliated itself with eBay or endorsed the sale of its products through eBay's website. End of quote. I'm bothering to quote from you the analysis from the opinion because that was basically it. That was the sum total of the Tiffany court's analysis of this issue of keyword advertising. A few short paragraphs, an easy warm-up question. Never mind that this is a multi-billion-dollar question to parties like Google or Yahoo or Bing or the rest. But more on that later. However, I can't resist that if you are way ahead of me on this issue, I should point out that eBay had purchased sponsored links keyed to Tiffany, and crucially, the text of these sponsored links in some cases included the Tiffany mark itself. In one such link, apparently quite innocently mentioned by the Second Circuit in its brief discussion of this issue, eBay repeated the term Tiffany twice in the Yahoo sponsored link that the court cited as an example. No problem, apparently, in the Second Circuit. Fairly stunning, 2 or 3 paragraphs on this issue. One other final note on the nominative fair use issue in Tiffany. The great metaphysical issue of trademark use never appeared in the Second Circuit opinion. And in this regard, I suggest to you that this issue of use is more or less dead in the US, and thank God for that. Courts now focus on the empirical question of consumer confusion, the core of trademark law, rather than this weird formal question of use. Though Professor Dinwoody, whom I see in the audience, might disagree with me about my characterization of this state of affairs, something we can talk about. But the main event in the Tiffany case was the question of indirect liability in the nature of contributory liability. Vicarious liability was not at issue at all in the Tiffany Second Circuit opinion. Here, the Second Circuit drew from the so-called Inwood test for contributory liability from the 1982 Supreme Court case Inwood Laboratories v. Ives Laboratories, in which the defendant was a manufacturer and distributor of generic medicines to pharmacists who did or did not insert those medicines into branded bottles. And you can imagine the rest of the facts of the case. The Inwood test finds contributory liability in the context of services if either 1, the service provider, quote, intentionally induces another to infringe a trademark, unquote, or 2, the service provider, quote, continues to supply its service to one whom it knows or has reason to know is engaging in trademark infringement, unquote. Tiffany did not argue inducement, so the contributory infringement issue focused on the second prong of Inwood, going to whether eBay, quote, and again I'll read this out because it's fairly important, continued to supply its service to one whom it knows or has reason to know is engaging in trademark infringement, unquote. And the precise reference to one plays some role in the Second Circuit opinion, as I'll show you in a moment. Now, with respect to the issue of counterfeit sales on eBay, eBay had and still has a very well-developed and well-resourced, at least in my mind, notice and take-down procedure, the so-called VERO program, Verified Rights Owner program, in which trademark owners can submit notices of claimed infringement, and eBay typically responds to them within 24 hours, if not within 12 hours. The Second Circuit quickly found that no liability arises with respect to these terminated listings, and Tiffany did not appear to press this point on appeal. When eBay gained actual knowledge of an infringing listing, it acted sufficiently promptly to avoid liability under an actual knowledge standard. Instead, the heart of Tiffany's case essentially went to constructive knowledge, or to a form of constructive knowledge. Tiffany argued that eBay knew, or at least should have known, or should have had reason to know, of the widespread sale of counterfeit merchandise on its auction site, and that despite this knowledge, eBay continued to make its services available to infringing sellers. eBay had general knowledge of widespread infringement, so went the argument, and failed to act on this knowledge. To make a long story very short, the Second Circuit rejected entirely this argument. It held that general knowledge is not enough. And like our Viacom v. YouTube case, this is a decisive holding by the Second Circuit. Viacom v. YouTube was on the copyright side and dealt with generalized knowledge, and here we now are on the trademark side dealing with the same issue. Inwood requires, wrote the Second Circuit, quote, some contemporary knowledge of which particular listings are infringing or will infringe in the future, unquote. eBay must know of and fail to act on, quote, specific instances of actual infringement, unquote. This is decisive, incredibly significant holding, a shift of value from one side to the other in the order of billions of dollars. And in this regard, the District Court Tiffany opinion, and to a lesser extent the Second Circuit opinion, relied on the particular phrasing So that's the phrase used by the Second Circuit. The particular phrasing of the Inwood test referring to one whom it knows or has reason to know. This reference to one implies a degree of specific knowledge that eBay didn't and doesn't and probably never can have. No other auction site like it or general intermediary like it will ever be able to have this before the fact specific knowledge. So that's the law, and reassuringly, it hasn't changed over the past 2 years. If you were to look at every case since 2010 that is cited to the Tiffany opinion, as I've had the pleasure of doing over the past few days, you'd find that other courts are falling into line without hesitation. It's simply not that controversial. I realize the European context is quite different. In the US, it's sort of that simple, at least on the surface. So what can we make of this decision? Needless to say, we would appear to be a long way from Europe with all the subtleties of Article 14.1 of the E-Commerce Directive, or of what Article 11 of the Enforcement Directive means for injunctive relief in such cases, or indeed of which of the two innocent persons is going to suffer, borrowing a phrase from a recent opinion on this side of the Atlantic. The second prong of the Inwood test would appear to be essentially binary in nature. Either the contributory defendant has knowledge of the infringement and must cut off its service, or does not have knowledge and is free to continue to supply its service. This would appear to be a regime without any standard or duty of reasonable care, without any notion of red flags, as again we have on the copyright side in the Digital Millennium Copyright Act in the US, and without anything in it to protect the interests, in short, of trademark holders. And if we are to accept the argument of my co-teacher at NYU, the Debevoise and Plimpton partner David Bernstein, then Tiffany represents in this regard a significant departure from previous brick and mortar case law on contributory trademark infringement, such as the Phono Visa v. Cherry Auction case or the Hard Rock Licensing v. Concession Services cases in the US. These cases arguably found contributory liability based on the contributory defendant's general knowledge of counterfeit sales at their flea markets, and were altogether taken up with the issue of the appropriate standard of care for these flea market operators. But perhaps I'm not being entirely fair to Inwood as it was applied in Tiffany. At the district court level, Judge Sullivan went to great lengths to describe all the measures eBay has taken to limit the sale of counterfeit goods on its website. The Second Circuit also spent a relatively large proportion of its opinion discussing these same facts, and discussing not just the Vero program, but also eBay's so-called fraud engine, dedicated to detecting infringing listings through the application of all sorts of sophisticated filters. Also, the thousands of eBay employees devoted to trust and safety, the Trust and Safety Department. Also, the About Me page on eBay that Tiffany can use to say, as it does, that most Tiffany merchandise on eBay is, in fact, counterfeit. Also, special automatic warnings, the Second Circuit referred to, as well as Judge Sullivan at the district court level. Special automatic warnings that would be sent to posters of Tiffany-branded merchandise saying that the posters could be subject to various anti-fraud measures. And finally, in 2006, additional anti-fraud measures that gave Tiffany a 6 to 12-hour grace period to review Tiffany-relevant listings before they would be made public. All of this stuff about how careful eBay has been. The question is why? Why bother with all of these facts? Why did the SDNY and the Second Circuit care about this stuff? What does any of this have to do with a standard that requires contemporary knowledge of specific listings to contribute to trigger contributory liability? The answer is probably obvious to you. Regardless of the specifics of the Inwood test, eBay was making the case that it was going to great lengths to take reasonable precautions against infringement and should thus not be held negligent. And the Second Circuit appeared to be persuaded by this, as is clear in its brief discussion of willful infringement, a finding of which will trigger a finding of constructive knowledge. In a footnote, the Second Circuit commented that Tiffany's reliance on the flea market cases is unavailing. eBay's effort to combat counterfeiting far exceed the efforts made by the defendants in those cases. Who here then doubts that if eBay had done nothing to minimize counterfeit sales, the Second Circuit would have found contributory liability, as federal courts routinely have for flea market operators, whether these operators had general knowledge, actual knowledge, specific knowledge, or some other form of knowledge. One is tempted to say that the issue was ultimately not so much one of negligence, in fact, as of who would be the lowest cost enforcer of the right. eBay, by its own conduct and technological measures, imposed on Tiffany the burden of being this lowest cost enforcer of the right. And this, I think, is a fairly significant move that these technology intermediaries, these technology companies, these intermediaries can make, is through their technology, they can force the efficiency analysis to choose the plaintiff as the lowest cost enforcer, the most efficient enforcer of the right. Meanwhile, despite eBay's apparent gutting of the notion of constructive knowledge, the cause of action for contributory trademark infringement is alive and well, I assure you, in the US. Consider the flea market case of Coach v. Gata Corporation out of the District of New Hampshire in 2011, which made a very conventional finding of contributory infringement. Quote, "The bottom line is this," wrote the court. "Like the defendant in Tiffany, defendants in this case knew that vendors were using the service they provided to conduct infringing activities. The defendant in Tiffany barred those known infringers from using a service. Gata did not. And thus liability, contributory liability was found." Or consider Gucci v. Frontline Processing Corporation, 2010 out of the Southern District, which declined to dismiss Gucci's causes of action against various credit card processing companies for contributory trademark infringement. In Frontline, Judge Baer of the Southern District relied heavily on Judge Kaczynski's dissent from the Ninth Circuit, in which Judge Kaczynski would have denied Visa's motion. This is the dissent in Perfect 10 v. Visa, Ninth Circuit case from 2007, in which Judge Kaczynski would have denied Visa's motion to dismiss causes of action for contributory copyright and trademark infringement. If we had a bit more time, I'd also talk about a very interesting aspect of the Tiffany v. eBay case in the US, and that is the false advertising cause of action that Tiffany brought against eBay. This claim appeared actually to have legs. It certainly wasn't at the heart of the case, but it was one of these sort of minor claims that could very well have caused a lot of trouble for eBay. And it may be something to keep an eye on in the future, if only because it is a cause of action that trademark owners can use to harass AdWord buyers or search engine websites. Tiffany's argument was essentially, and I'm boiling it down considerably, was essentially that eBay's sponsored links in announcing the availability of Tiffany merchandise on eBay failed to inform consumers that some of this merchandise was in fact counterfeit. And thus the sponsored link text could cause consumer confusion as to the true nature of the goods on the eBay website. But tragically, Tiffany's lawyers failed to develop a good record of extrinsic evidence of consumer confusion. In the US, we require extrinsic evidence of confusion in the false advertising context. This would have been a trivial thing to do, I put it to you, for Tiffany's lawyers to do, a few surveys and that sort of thing, but they failed to do so. So enough of Tiffany v. eBay for the moment. Let me turn to another leading case in the relation between trademark law and the internet, which is, of course, Rosetta Stone v. Google. For those of you who are unaware, Rosetta Stone is a language learning software producer, and it also produces ads, which you might have seen in various magazines, with copy like, "He was a hardworking farm boy, she was an Italian supermodel, he knew he would have just one chance to impress her." And I'm sure you've seen that flying somewhere. Though this is a quite interesting case, I'll try to be quite brief to come within my time limit. As it arguably was for eBay and Tiffany, Google's entire business model is at stake in Rosetta Stone. Almost all of their earnings come from keyword advertising, and if they lose Rosetta Stone, they're in a lot of trouble. But rather than begin with Google's side of the story, consider what's at stake for trademark owners in Rosetta Stone. Imagine if the domain name system were an auction-based system, in which, say, Pepsi could outbid Coke for ownership of the Coke.com domain name, and having done so, run Coke.com as an advertising site for Pepsi-branded products. We would, of course, find this to be outrageous. Or would we? I don't know. Certainly, I think nowadays, given the context in which we live, we'd probably find this outrageous. The question then is, what is so different about Google's AdWords program? This is a program in which anyone can bid on search terms, including others' registered trademarks, in order to have their advertisements served as sponsored links whenever a search engine user enters that search term into the search engine. The higher you bid, the higher in the list of sponsored links your particular sponsored link appears. It might even appear in the Google situation at the top above Google's what they call organic links. And in the US, at least, the sponsored links at the top appear with this very slight yellow background. That is, just, you basically can't see unless your monitor is perfectly tuned, and a tiny little word that says ad, or sometimes sponsored link, which leads one to believe that Google's really, up to something here. I mean, there's some bad faith in that. In any event, the answer to this question, how is this different from the domain name system, is that Google AdWords program is fundamentally different from the domain name registration system in a variety of ways. But try telling that to trademark owners, who have expended enormous resources building up brand equity and who are told that this time they must pay not a flat registration fee for a domain name during a sunrise period, but actually have to bid against their competitors for access to their own mark. In any event, I predict, and I'm certainly not alone by any means in making this prediction, that Google will eventually prevail in Rosetta Stone. And I think its stock price already suggests that the market is predicting this as well. Let me try to defend this prediction by describing certain aspects of Google's AdWords policy in the US at the time of the case. And it's important to realize just how precise certain of these aspects are, and you'll get a sense of how Google will avoid liability. In 2004, Google began to allow third-party advertisers to bid on specific trademarks as keyword triggers for sponsored links. It did not, however, permit the use of the trademarks in the text of the sponsored link itself. Why did Google wait until 2004? Well, a bit of awkwardness in the sense that Google had conducted internal surveys which appeared to show that, at least before 2004, consumers would be confused by sponsored links that were served according to certain keywords. But then Google said, well, we've changed our technology a bit. Perhaps consumers have become more sophisticated, and there will no longer be this kind of confusion. In 2009, Google modified its AdWords policy additionally to allow the use of trademarks in the text of the sponsored link, though only under certain conditions. It is worth spelling these conditions out. The third-party advertiser may use another's trademark in the text of its sponsored link in a nominative sense, and Google on its website actually uses the term nominative and essentially appropriates much of American trademark law and just sticks it on its website and says, as long as you do this, you're allowed to use your sponsored link. A third-party advertiser may use text in the sponsored link if, one, it resells legitimate products bearing the trademark, or two, it sells components, replacement parts, or compatible products corresponding to the trademark, or three, provides non-competitive information, Google's term, about the goods or services corresponding to the trademarked term. What does this non-competitive information mean? I'll quote from the Google website. The landing page may not sell or facilitate the sale of the goods or services of a competitor of the trademark owner. That's the third requirement if you want to use a competitor's trademark in the text of your sponsored link. How does Google, of course, enforce these conditions, you might ask? It employs an automated counterfeit filter to evaluate the landing page to which the sponsored link is linked to assess the bona fides of that page. If the filter detects certain terms associated with counterfeit goods, it will reject the sponsored link. Google also has a notice and takedown process that responds to complaints by trademark owners, such as the hundreds filed by Rosetta Stone, who have identified sponsored links linking to counterfeit sellers. The sum of this may not be so impressive as what eBay is able to tell a court, but it is certainly along those lines, as it again uses technology to make others the lower cost enforcers of the right. To boil the Rosetta case down to its essence, in my time remaining, and I've just got a few more things to say, let me focus on two issues in the case that you might find of particular interest. Fortunately, again, I need not address the issue of trademark use because it hasn't played a role in the case. And in Network Automation via Advanced Systems Concepts, a Ninth Circuit case 2011, I think we can finally put to rest any questions about the use concept in keyword advertising when the Ninth Circuit found the use of a trademark as a search, I'm quoting, the use of a trademark as a search engine keyword that triggers the display of competitors' advertisement is a use in commerce under the Lanham Act, end of quote. And cites to the RescueCom case out of the Second Circuit, cites to a few other cases, and that's it. No more analysis. We're done. Nor do I need to say much about the Eastern District of Virginia's treatment of secondary liability in the Rosetta Stone case, because it essentially followed eBay v. Tiffany and found that there was no secondary liability. Instead, I'll focus first on the issue of trademark functionality, and second, on the core issue of likelihood of consumer confusion. As to functionality, if you're familiar with the concept in the US or in Europe as well, you might ask, what on earth am I doing talking about functionality in the context of keyword advertising? In the American scene, the doctrine of trademark functionality typically applies to three-dimensional product features, which are functional if they are essential to the use or purpose of the article, or affect the cost or quality of the article. That's the phrase we use from our relevant Supreme Court opinion. And under our beguiling doctrine of aesthetic functionality, very interesting doctrine, we ask if exclusive rights in particular aesthetically appealing product features would put competitors at a significant non-reputation related disadvantage. It sort of rolls off the tongue after you practice that enough, a significant non-reputation related disadvantage. Well, I'm talking about functionality because the district court in Rosetta Stone found that, and I quote, Google's particular use of trademark keywords as triggers for paid advertisements is functional, end of quote. And thus such trademarks are unprotectable in this context, regardless of any showing of consumer confusion. What Google is doing is functional, and therefore the court says no liability will attach, even if there is in fact consumer confusion. Perhaps a bit of explanation is in order on this issue, so I'll quote one more sentence from the court opinion. If Google is deprived of this use of the Rosetta Stone marks, consumers would lose the ability to rapidly locate potentially relevant websites that promote genuine Rosetta Stone products at competitive prices, end of quote. And that too is essentially the analysis of the court. From an American academic's perspective, this is a fantastically interesting use of the concept of functionality. It implicates all sorts of issues about how trademarks can function in essence as gears. It's like DNA in a language, about machines reading trademarks and machine perception of trademarks. But from an American practitioner's perspective, I suggest to you this is a grotesque contortion of the concept of functionality in our law, and may very well be rejected by the Fourth Circuit. And yet, the Eastern District of Virginia is unreasonably solid ground because of two, I think, quite interesting cases out of the US on this issue. Consider first Sega Enterprises v. Accolade, a well-known 1992 decision out of the Ninth Circuit. Sega sought to prevent others from producing video game cartridges compatible with Sega's game console without Sega's permission. It did so by designing a console operating system that required any compatible cartridge to use the term Sega in its initialization sequence. So if you're a competing cartridge manufacturer, you got to use Sega's trademark in your code in order for your cartridge to be compatible. Very clever, huh? Well, the Ninth Circuit considered this issue under the rubric of functionality and called it a functionality question. It essentially found that this was a functional use of a trademark and ruled in favor of the defendant. A more obscure 1995 case from the Southern District of Texas, Compaq v. Procom, had comparable facts involving compatibility with a hard disk drive and came to a comparable conclusion. So this is quite exciting. We're waiting to see if the Fourth Circuit will continue this sort of application of the functionality doctrine beyond utilitarian functionality and aesthetic functionality into a context where we might call it, I don't know, software functionality or interoperability functionality, but it's hard to predict what they'll do. And I do regret, by the way, that this all seems to invite a return to the mire of trademark use. And for those of us who loathe the concept of trademark use, we may have to eat our hats, because it turns out that the concept may have real utility, especially in this kind of case, and not just to get rid of cases early on in the litigation. But I suspect that Rosetta Stone will turn on something far more central to trademark law. And this is why I suppose we shouldn't be too worried about the functionality issue. This is the likelihood of consumer confusion. And with this issue, I'll conclude my discussion of the Rosetta Stone case. It turns out that Rosetta Stone's evidence of consumer confusion is exceptionally weak, unbelievably weak. In his absolutely gorgeous brief for Google, Quinn Emanuel was able to argue, and this is what the district court also found, that, quote, out of the 100 million ads displayed on Google.com since 2004 in response to search queries that contain the Rosetta Stone mark, Rosetta Stone identified a mere 5 instances of actual confusion related to the purchase of allegedly counterfeit goods, unquote. 100 million impressions, 5 instances of actual confusion. And the district court found, now not quoting, and the district court found that in each of these 5 instances of actual confusion, the consumers knew that they were not purchasing the software from Rosetta Stone directly, but rather from someone else, thus implying perhaps a sort of buyer beware approach to this particular fact. Elsewhere in its brief, Quinn Emanuel may have gone a bit too far. In criticizing Rosetta Stone's clearly juiced survey, the brief asserts that, quote, if identification of those 2 ads in the survey is properly omitted from the confusion count, the net confusion reflected by the survey is, and the brief underlines and bolds this, negative 3% confusion. What does that mean? If you're into trademark law and you're familiar with this survey evidence, I'm not sure if you've ever probably seen negative confusion. But whatever, it's maybe good for a laugh for the judges and clerks reading the briefs. Other factors that will play a role in the Rosetta Stone case are intent, one of the important factors in our multi-factor test for likelihood of consumer confusion. And here Google was able to show, as eBay was as well, that it simply had no intent to abet the sale of counterfeit goods and was taking reasonable measures to prevent the sale of such goods. And then finally, quite interesting, the consumer sophistication factor. I think this factor is just extremely important in these cases. Google has argued that consumers have become more sophisticated, and in any event, those purchasing Rosetta Stone software, which is $400 a piece, are even more sophisticated and more careful, and so we shouldn't expect them to be confused. So perhaps this is all sort of a letdown. My description, not just of Tiffany v. eBay, but also of Rosetta Stone, especially for Europeans dealing with all the details of Interflora or Google France. After all the controversy of the use debate and now functionality, after all this controversy, we realize that Google's new policies, provided that the AdWord buyer follows them, and that Google can show it's making reasonable efforts to enforce them, will very likely preclude findings of consumer confusion triggered by sponsored links. And I suggest to you that what we might have in the future, or in the coming decades, is just little skirmishes about whether a particular AdWord buyer is complying with Google's policies. Google will very likely be able to show that it is reasonably enforcing these policies. So I'll conclude with just a few more paragraphs in the nature of general observations. I've already suggested that the technology companies are growing better at shifting onto the other guy the burden of being the lowest cost enforcer of the right. And if the American courts still are under the thrall of the law and economics approach to everything we call law, and I think that's an overstatement, but in any event, lower cost enforcer of the right is still a powerful claim to make in American courts, and the technology companies are shifting this onto other people. This is part of a larger trend. In the US, at least, the technology companies, as intermediaries, are winning. They're winning everywhere. One example of this is the recent demise of such legislative proposals as the Stop Online Piracy Act, known as SOPA, and the Protect IP Act, known as PIPA. These were essentially copyright legislation, but both bills address the sale of counterfeit goods. Companies like Google, eBay, and Amazon successfully opposed this legislation. To give you a sense of the nature of this legislation, I'll tell you that under PIPA, the government could require domain name servers, credit card companies, and search engines to cease to refer to or do business with, quote, any internet site dedicated to theft of U.S. property, unquote. What U.S. property means in that case is unclear to me. That means government property to me in some weird context. But this was part of the rhetoric of the bill to get it passed, that it was about protecting American property against counterfeiters from certain countries, in particular abroad. PIPA also provided for a private right of action by which the plaintiff could win an injunction only affecting credit card companies and internet advertisers. The domain name system would not itself be affected by this private right of action. More controversially, SOPA provided for a kind of notice and takedown process that would not in the first instance have been subject to court review. An intellectual property owner could simply notify a credit card company or internet advertising service such as Google of a, quote, foreign infringing site, and the company would be required to deny service to the site within 5 days unless it went to the trouble of filing a counter notification, in which case the case would be kicked up to a court. These were quite controversial proposals to be sure, especially the idea that domain name providers might themselves have to violate the sanctity of the domain name system by denying American internet users access to certain domain names. So why are the technology companies winning? One simple explanation may be that this was just incredibly bad legislation that was little more than an expression of Congress's now annual ritual of showing its content provider paymasters that it really is trying to do their bidding, but is not quite succeeding this year. Perhaps next year, after the next election, will be successful. This is sort of like how the Republican Party is always trying but never quite succeeding in satisfying the demands of the far religious right in the US. But I think a more trademark-specific explanation that goes especially to Tiffany and Rosetta Stone may be that the courts in the US in particular are still not completely sold on the importance of trademarks themselves as intermediaries and the value of brand equity. And I'm concluding with this observation. A good example of this, of how our courts are still not really sold on trademarks as opposed possibly to patents or copyrights, is what amounts to the judicial nullification of anti-dilution protection in the US. We tried in 1995 with the Federal Trademark Dilution Act. It was dead from the start. It was nullified by certain Second Circuit judges. We've tried again with the Trademark Dilution Revision Act of 2006. It's also, as an empirical matter, just not working, not making a difference. Because judges, I think, are somewhat hostile to certain aspects of trademark protection. On one side of cases like Tiffany, these courts have fantastically impressive and lawyered up high technology intermediaries like Google or eBay, and no doubt in time Facebook, the very pride of American capitalism at the moment. On the other side, they have Tiffany or Louis Vuitton or even Rosetta Stone. This balance affects courts' overall social welfare calculation and gives courts a degree of comfort with shifting the enforcement costs over to the trademark owners. And I'll conclude that.
Thank you. Our second speaker is Alex von Muhlendahl, who will be known to many of you, who's had a career in all kinds of different capacities: academic, civil servant in the German Ministry of Justice, vice president of OHIM for 8 years, and now in private practice. Alex, thank you.
Thank you very much, Your Honor, Sir Robin, ladies and gentlemen. I've been taught that a proper speech begins with and ends with a joke, or at least a smile. A smile? Yes, I hope so. However, no jokes today. An introduction. More than 125 judgments have been rendered by the European Court of Justice interpreting European Union's trademark law, and a similar number of decisions have been taken on appeal from the General Court. As a result, we know pretty well what distinctiveness and descriptiveness mean and how to define reputation, likelihood of confusion, and what cases should or should not fall under the exhaustion when medicines are rebranded, co-branded, debranded, and repackaged, and what genuine use means. A big and perhaps even useful and well-deserved effort with rather limited results. Many other issues are still outstanding, such as whether intent of use is a requirement for access to trademark protection. Also, as regards infringement, while we have some general view of what may constitute infringing acts: use, offer for sale, placing on the market, transporting goods in transit, we have barely begun to look at the issue of who is liable. The Court of Justice has in fact never analyzed trademark infringement, or more generally IP infringement, under the aspect of personal liability, but has instead sought to determine liability on the basis of whether the respective acts fall within the ambit of the exclusive rights, i.e. the right to exclude others. The advent of the Internet has changed the playing field. Notions of use limited to a particular jurisdiction are no longer valid. The actors involved in IP infringements have multiplied, and they are often entirely out of the jurisdiction where the infringing acts are committed or have their intended effect. For example, offering Rolex or Cartier replicas made in China or elsewhere via spam email sent by unknown senders to an unknown number of addressees. How can the rights to the Rolex name or mark be effectively enforced? What is the situation when such replicas are offered on auction sites like eBay? With or without the intervention of search engines? We have become familiar with cloud hosting, file sharing, etc. Are these novel services themselves liable for infringements, mainly in this case of copyrighted works? In our pre-internet digital, non-digital lives, we had to deal with parallel situations in the analog world. Does the publisher of a newspaper or magazine have some, and if so, what responsibility for infringing ads published in his journal? Does the landlord of a building owe the proprietor of an IP right an obligation to prevent the selling of infringing goods on his premises? Can you sue the city for tolerating the sale of counterfeit goods on its streets? Can the maker of video recording device be held responsible for copyright infringements committed by purchasers of the device? Among the questions we are looking at today is the question whether these analog cases are similar to the ones currently raised with regard to the digital universe. Google, just to remind you, and we heard some of this already from Barton Beebe, the leading search engine was founded barely a decade ago. Currently, Google's revenue, more than 95% from advertising, is about $39 billion per year and rising fast. And income is at about $12 billion a year, a 30% margin, which traditional undertakings, or as they're called in Brussels, economic operators, rarely have. Much, if not of this money, is paid by advertisers whose ads appear on Google sites as a result of the purchase of words. AdWords is the program. AdWords is, by the way, a Google-protected trademark in the European Union since 2002. And which, more often than not, these, of course, consist of third-party trademarks. Take YouTube as another example, a platform which is barely 5 years old, and which currently has some 50 hours of new video uploaded every minute, which adds up to 3,000 hours every hour, or 27,000 hours every 24 hours every day. Advertising on that side, as it is on Google, is addressee driven rather than content driven, as it was in more traditional media. My presentation today deals with liability for trademark infringement in the non-traditional settings of the internet, but I will have references occasionally to our brick and mortar analog world as well. Specifically, I will analyze the question of who should be liable rather than for what liability should be recognized. In the traditional world of IP protection, the question of who is liable is not generally the focus of attention. Nevertheless, some questions may be asked. Liability of legal entities is usually predicated on some acts done or sanctioned by their organs, usually the office of the company. What happens, however, if some employee or agent of the legal entity is responsible? Do we have a vicarious liability principle applicable to the entity itself? No rule exists as far as I know in EU law. What happens with regard to liability for preparatory acts, such as the making of labels to be affixed to goods or their packaging? Again, we have nothing in European law as far as I'm aware, but we find in ACTA, and I could talk also about ACTA as we heard about the PIPA and SOPA in America. In ACTA, we find a rule that member states shall make provisions which prevents the use on a commercial scale of labels or packaging which are supposed to be linked with the goods or services for which they are to be used. If we turn to other acts committed with regard to infringing goods other than the making, offering for sale, putting on the market, and so on, which we would qualify as direct infringement, we have the difficult task of determining who is the direct infringer. For example, in Germany, in the case involving alleged patent infringement, the question had to be decided whether a shipper or forwarder is an infringer when the goods shipped are patent infringing. Try to consider the answer to that question under your respective legal systems. How about acts committed by several persons acting together, something which we call in German Mittäterschaft, co-actors? How do we deal in Europe with indirect infringement? And finally, and now the center of our inquiry, what situation with regard to persons contributing to infringements committed by others in one way or another, such as by aiding, abetting, inducing, or procuring the infringement? Are they liable? Under which theory? A criminal law theory or a tort law theory where you analyze the respective duties of the parties to each other? Or do the Germans again provide a viable answer with the theory of the so-called Störer, a person providing the means of committing infringement without being an infringer himself? Again, nothing on such situations is found in EU trademark law, but we do have at least rudimentary rules elsewhere to which I will turn in a minute. But first, let me have a look with you at the search engine and internet auction platform cases which have been brought before the European Court of Justice and which by now have all been decided. The issues that arose in these cases were, first, liability of the search engine operator, in this case Google, for providing the means of selecting and collecting money for the use of third-party trademarks as AdWords. Second, the liability of persons placing advertisements on the website showing the natural search results, liability for the purchase of third-party trademarks and for the placing of the advertisements. And finally, the liability of internet auction platforms such as eBay for infringing goods offered on its website. And the Google cases decided in March 2010, three parallel cases that had been referred by the French Cour de Cassation, the highly regarded and very learned Portuguese Advocate General Poires Maduro, now a professor at the European University Institute in Florence, observed or concluded that European trademark law did not comprise the notion of contributory infringement or third-party liability, supposedly leaving it for each member state to decide whether cases of non-direct infringement would or would not result in liability. He said, the goal of trademark proprietors is to extend the scope of trademark protection to cover actions by a party that may contribute to a trademark infringement by a third party. This is usually known in the United States as contributory infringement. But to my knowledge, no such approach is To my knowledge, such an approach is foreign to trademark protection in Europe, where the matter is normally addressed through the laws on liability. That statement was and is of course wrong as regards trademark protection in Europe, as the long debates about third-party liability in practically all European jurisdictions show. I also find it difficult to accept that trademark infringement is somehow divorced from tort law in general, or what is called by the Advocate General somewhat indistinctly the laws on liability. In the relevant footnote, only 2 publications referring to French and Belgian law are cited. We will see that European law as well has a possible source for the development of rules on third-party liability. The full court neither endorsed nor rejected nor even mentioned this analysis. Instead, the court concluded on a narrow literal construction of European trademark law that Google did not use the third-party marks in its own commercial communication. While commercial communication is a novelty in trademark infringement analysis, the result is a sequel to earlier but still recent ECJ judgments requiring use of the allegedly infringed mark by the infringer for the infringer's own goods or services, not those of the trademark proprietor. For me, an illegitimate offspring of Arsenal, already appearing in the O2 judgment in plain contradiction to the multitude of exhaustion cases decided over the years by the same court. So, no liability for Google. As regards the advertisers purchasing and placing advertisements on the websites of the Internet referencing service, that is the Google search engine, their liability differs according to the court depending on whether it's a case of double identity, whether the allegedly infringed mark has a reputation, and in other cases where protection depends on likelihood of confusion. This has to do with the novel theory developed by the European Court of Justice that in double identity cases you must take into account, in addition to the likelihood of confusion analysis, the so-called advertising, communication, and investment functions of trademarks. I will not go into this quite traditional trademark infringement analysis, but instead turn to the auction platforms. As regards the liability of eBay, eBay was found not liable for the purchase of AdWords consisting of the marks for goods available on its website. Again, no use for its own products or services. However, as regards liability for fake goods available on its website, the court had no difficulty in finding the proper legal basis for the analysis, no doubt aided by the wording of the reference to the court produced in all detail by our learned moderator, namely the third sentence of Article 11 of the Enforcement Directive, which reads as follows. Member states shall also ensure that right holders are in a position to apply for an injunction against intermediaries whose services are used by a third party to infringe an intellectual property right. Before, however, coming to the application of Article 11 of the Enforcement Directive, we must consider the regulatory context also mentioned by our moderator in his introduction, in which Internet service providers operate and the rights and limitations provided in that context. It becomes clear from the L'Oréal eBay judgment, as had become apparent already about a year earlier from the judgments in Google, that the legal bases to be considered for relief against Internet service providers include not only the substantive law of intellectual property rights, EU law in the case of trademarks, or non-harmonized law, the laws of the member states, as well as the 2004 Enforcement Directive, but also the so-called e-commerce directive of 2001, which deals in general terms with the operation and liability of information society service providers. These are defined, by the way, not in that directive itself, but in another directive, and essentially we talk about services normally provided for remuneration at a distance by electronic means and at the individual request of a recipient of the services. The general scheme with regard to Internet service providers established in an EU member state, we're not talking about third country ISPs, is that they are, as far as the coordinated fields are concerned, subject only to the law of the member state of their establishment. An exception as to the applicable law is provided for, among others, intellectual property rights, where the law of the member state of infringement applies. The directive also contains a series of general provisions limiting the liability of Internet service providers, which fall within certain categories, namely the connection service providers, also called as the mere conduit, the cache service providers, and the hosting service providers. In the situations that we are considering here, notably the search engines with advertising content and the internet auction platforms, the first issue to be determined is whether they fall with any of the three categories with regard to which the directive provides for a limitation of liability. It seems obvious that Google and eBay are neither mere conduits, connecting services, nor are they caches, but they may fall within the hosting definition. This requires, according to the European Court of Justice, that the activity is limited to an automatic processing of data. That is, so the court, not the case where the service provider, instead of confining itself to providing that service neutrally by merely technical and automatic processing of the data provided by its customers, plays an active role of such a kind as to give it knowledge of or control over these data. The operator plays such a role when it provides assistance, which entails in particular optimizing the presentation of the offers for sale and in question or promoting them. If the activity should fall within Articles 12 to 14 of the e-commerce directive, the next question is under what circumstances the exception or limitation of liability does not apply. Taking Article 14 as an example, that is the hosting exception, the limitation does not apply when the internet service provider has actual knowledge of illegal activity or is aware of facts and circumstances from which the illegal activity or information is apparent. The requirement are thus knowledge or awareness plus inaction. The court in L'Oréal versus eBay has given a rather broad interpretation to that obligation by stating that the service provider cannot rely on the exemption from liability if it was aware of facts and circumstances on the basis of which, and now it comes, a diligent economic operator should have realized that the offer for sale in questions were unlawful and, in the event of being so aware, failed to act expeditiously in accordance with Article 14 of that e-commerce directive. It remains to be seen what the National Court, and here again Mr. Justice Arnold, we assume, will do with that Delphic statement. If we assume that the exemption in Article 14 does not apply, then we have to answer the question as to the law applicable to determine liability as well as finding the appropriate sanctions. It seems clear that the law in our situation is trademark law, or as the case may be, copyright law, and the sanctions are those provided under national law in accordance with the hopefully implemented enforcement directive. If the service provider does not fall under any of the Article 12 to 14 directive rules, he would be considered a content provider, fully subject to the law of the country of establishment and also the laws of the country of infringement in the case of IPR infringements. It is in this context that Article 11, or specifically the third sentence of that provision of the enforcement directive, becomes operative. The court in L'Oréal versus eBay decided on July 12 this last year, rather forcefully, came out in favor of a broad obligation of internet service providers of the type of eBay holding as follows. The provision must be interpreted as requiring the member state to ensure that the national courts with jurisdiction in relation to the protection of intellectual property rights are able to order the operator of an online marketplace to take measures which contribute not only to bringing an end to infringements of those rights by users of that marketplace, but also to preventing further infringements of that kind. These injunctions must be effective, proportionate, and dissuasive, and must not create barriers to legitimate trade. The court also analyzed some of the measures that the auction site might be required to take in a number of paragraphs. The first one that it refused to be available or considered unavailable is a general monitoring obligation. The second one, which is also rejected, a general prohibition to offer or for sale or purchase trademark goods on the website bearing these marks, is also disproportionate because it would constitute a barrier to legitimate trade. They can, however, order the suspension of the perpetrator of the infringement. They can also order that the internet service provider must make available to the rights holder information on the data of the person so that the individual person can be pursued. All of this must lead to a proper and fair balance between the rights involved. This brings me to the other provision which has been interpreted, and that is Article 8, Paragraph 3 of the so-called Information Society Directive, which deals with copyright. That provision had led a somewhat sleeping beauty life until it was brought to full bloom in the judgment of 28 July last year by the Honorable Mr. Richard Arnold, once again, in 20th Century Fox versus British Telecom. Just a few days, in fact 16 days only, but fully taking into account the ECJ's L'Oreal versus eBay judgment. I do not have the time to go into the copyright side of our issue, but in many respects the questions and the applicable law are very similar. Indeed, Article 11, third sentence of the Enforcement Directive is substantially the same as Article 8.3 of the Information Society Directive adopted 3 years earlier. If we summarize what has been said so far, the analysis goes as follows. In brick-and-mortar analog situations, we apply the sanctions in cases of trademark infringement not only against direct infringers, but also against the variety of other actors, in any event in accordance with the rules on liability under national law. In addition, Article 11, third sentence of the Enforcement Directive applies to so-called intermediaries, such as publishers, perhaps also to landlords. In internet-based situations, we first determine whether we have, as will normally be the case, an internet service provider. Next, we must determine whether the provider falls within one of the categories of providers governed by Articles 12 to 14 of the e-commerce directive. In that case, liability limitations apply. Whereas a breach of these obligations, liability is incurred under the respective substantive law, which covers intermediaries in accordance with Article 11 of the Enforcement Directive. Where the internet service provider does not fall within these articles, full liability under the applicable law applies, including intermediary liability pursuant to Article 11 of the Enforcement Directive. This brings me to the final step in my analysis. The final step requires us to determine whether the sanctions available against internet service providers are the same as against analog infringers. This brings us to Article 15 of the e-commerce directive and further to Article 3 of the Enforcement Directive applicable to all sanctions against all infringers of any IP right. The first of these, Article 15 of the e-commerce directive, provides that member states shall not impose a general obligation on providers when providing the services covered by these mentioned articles to monitor the information which they transmit or store, nor a general obligation actively to seek facts or circumstances indicating illegal activity. And under Article 3 of the Enforcement Directive, all measures that are taken in the enforcement of intellectual property rights must be fair and equitable and shall not be unnecessarily complicated or costly or entail unreasonable time limits or unwarranted delays. The measures must be, and again I quote, effective, proportionate, and dissuasive, and shall be applied in such a manner as to avoid the creation of barriers to legitimate trade and to provide safeguards against their abuse. As regards internet service providers which do fall under these Articles 12 to 14, while sanctions may be imposed on them in case of violations which remove their exemption from liability, in any event under Article 15 of the directive, the sanctions may not include an obligation for a priori monitoring. For internet service providers not within this category, the similar limitation arising under Article 3 of the Enforcement Directive applies. And again, the L'Oreal eBay case has already laid the groundwork for that. The balance between the IP rights owners and intermediaries, such as search engines and auction platforms, file sharing services, must be set so as to permit the carrying out of legitimate businesses, but also must permit the protection of IP rights. The very recent Court of Justice judgment in a case called Scarlet Extended versus Sabam, a copyright case summarized in balance in a clear and succinct, if still Delphic manner, what the rules are. In that case, the legality of a blanket order requiring a file-sharing operator to install comprehensive control mechanisms was challenged and was held by the ECJ to be disproportionate. The court referred inter alia to the following. The protection of the right to intellectual property is indeed enshrined in Article 17, paragraph 2 of the Charter of Fundamental Rights of the European Union. There is, however, nothing whatsoever in the wording of that provision or in the court's case law to suggest that the right is inviolable and must for that reason be absolutely protected. Rather, and that is the finding, there must be a proper balance be drawn against the other rights. That is the right of the freedom to conduct a business. It's also the fundamental rights of persons to their private data under the data protection rule, and the right to freedom of information. Thus, we actually do not need Article 15 of the e-commerce directive to get to the result that an a priori comprehensive monitoring system to prevent infringing goods or services to be available on the relevant websites is not a solution which is acceptable under European law. If I summarize what I've been saying so far, we find the following. Google and similar so-called referencing services are not direct infringers when they sell third-party trademarks as AdWords. They are, however, intermediaries within the meaning of Article 11 of the Enforcement Directive and thus liable for infringement committed by third parties through advertisements placed on Google's website. However, which is the law that Google might infringe as intermediary? Apparently not European trademark law, but some doctrine of national law would seem to be applicable. If Google can be qualified as a host within the meaning of Article 14, its liability under any theory would require that they are in violation of the exemption provided for in Article 14. In any event, removal of infringing material can be requested. As regards the prevention of future infringements, we do know that a general monitoring requirement cannot be imposed. Are there intermediary solutions? Is that satisfactory? I don't think so. Trademark owners will not be happy with Google selling the advertising potential of their marks to third parties who wish to be associated with the reputation or distinctiveness of the mark and attacking the infringing advertisements instead of Google. The operator of the website is a tedious exercise. I find it also unsatisfactory that the law does not provide some relief to the trademark owner, such as the right to opt out of any of these advertising systems. eBay and similar auction sites are unlikely to fall within the hosting category. They are thus subject to unlimited liability under the e-commerce directive for trademark or IP infringements, provided other IP infringements. Provided, of course, that what they do amounts to infringement. It is unlikely to be direct infringement. We are thus left with the intermediary liability under Article 11 of the Enforcement Directive. Under this directive, and thus under any national law dealing with the enforcement of IP rights, again, a removal of infringing material may be requested, which puts the burden of monitoring on the IP rights owner. A general monitoring requirement cannot be imposed. However, eBay and others are obliged to create and maintain a system which not only suppresses committed infringements, but which also effectively prevents future infringements of the same kind, while not amounting to a barrier to legitimate trade. How such a system or such measures might look like, the Court of Justice is not going to answer this, except perhaps in the negative, as in Scarlett extended. The Court of Justice is not an appellate court, nor has it jurisdiction or power to set the contours of such a system. This is a matter for national courts. Thus, we turn to our judges, and Mr. Justice Arnold in particular, who will have the task of implementing the L'Oreal versus eBay judgment and the Interflora judgment as well, in addition to solving the copyright issues arising under Article 8.3 of the Information Society Directive. No envy here on my part. Is the world of the Internet truly different from that of the analog world? Probably not as far as the legal results are concerned. Factually, however, we live in two different worlds, digitally virtual and analog. And the factual issues arising in the virtual world, which we have been able today to consider under one of the many IP-related aspects, continue to challenge our legal intellect. I will close with these remarks. Thank you very much for the invitation of UCL and Sir Robin to come here to speak to you. Thank you very much.
So we've had two tours de force there. We have time for a couple of questions. Who would like to go first? Please wait for a roving mic to arrive.
I'd like to ask a question about functionality, the concept of functionality in US law. So why is there this idea of functionality by mark rather than functionality by description?
So this is a very difficult question. I have to admit, as a US trademark lawyer, when I hear essential to the use or purpose, I always am thinking of three-dimensional objects. And so I have a hard time wrapping my head around how a trademark can serve an essential function in referring a consumer to a particular product. But the way you phrased it in your question clarifies it considerably for me, in the sense that, I don't know, one approach to this, an indirect approach, is to say, you know, when we talk about nominative uses of a trademark, it's very difficult for competitors to refer to Google other than by the term Google. What else would they say? The search engine that dominates the internet and 95% of whose revenue comes from keyword advertising. That long phrase is just no good, and a much more powerful, direct way of referring to the to Google itself is just to use the Google term. One thing that you mentioned, which is quite interesting, is which has come up in some of the US cases, though very much passingly, is the idea that internet users use search engines to find products by typing in something like, you know, Dell for computers, expecting to get a listing not just of Dell, but quite possibly of, I don't know, Toshiba, Samsung, Sony, and even possibly Apple, you know. And so the trademark itself is used as a quick way to access all of the competitors as well. And would we call that then an essential way of accessing the competitors? There I'm tempted to say, I think I'm agreeing with you, no. It's not necessary that a internet user be empowered to use the term Dell in order to gain access to Dell's competitors' websites. There is an alternative. They can just type in laptop computers or you know, other kinds of computers. So this, following through now, I'm thinking along the lines of your question and argument, yeah, it's quite delicate in that it may be that there's no reason why Google should be able to use these kinds of trademarks when there are substitutes, there are competitive alternatives available going to a different version of functionality test in the US that Google could use. I don't know if that answers your question.
All right, let's have another question.
Hi. The concept of legitimate use. The question I wanted to put to anyone who wanted to answer it is the fact that legitimate use is exempted in an area where we don't really know what legitimate use is in the first place. We're in an area where the nature of trade and the nature of use of trademarks is constantly changing. Does it not make this area of law become an issue of sort of effectively policy around what should be legitimate and what shouldn't be, rather than applying the law that's already there?
Alex, do you want to have a go at that?
Now, the easy answer for Europe is to say we don't worry about Google because Google doesn't infringe. Period.
Well, quite.
So we don't even have to do this. If you did different, and if you did the analysis similar to American law, you would say, yes, of course, Google uses the trademark. It uses a third-party trademark without their consent, and it uses in the course of trade. And then you come to the question, should they be allowed to do it? Under which particular conditions? And we have a theory of what we call fair use in Europe, which gives three cases. It's the names and the descriptive use and the replacement and spare part business. We do not have a proper definition of nominative use of a trademark. It may well be that Google, in some situations anyway, should be allowed to do that. It's so strange that this issue comes up only during the last essentially 6 years. No one previously knew anything about AdWords, and no one made any money by selling someone else's trademark to be placed next to it. But the European answer is we do not have to have certainly no functionality analysis, and we do not need, with regard to Google, to do a fair use exception, although we could develop it. I don't see the Court of Justice developing it. Of course, we still have other problems. Google as an intermediary. What is the law you apply if they're not direct infringers? What are they? So
All right. One more question, perhaps?
I'm going to have a comment.
Robert.
As a sort of ancient trademark lawyer who actually looked back in time, some of these questions were actually addressed in the 19th century cases. You may say, well, no, they weren't internet cases, but what do you do about carriers or warehousemen? Let me just give you an example of the way the common law adapts. It's a great case. It's called Washburn and Moen against Cunard, the shipping line, and 6 reports of patent cases. Cunard were carrying some patent-infringing barbed wire to the United States. The United States had great need of lots and lots of barbed wire because they were covering the whole of it with barbed wire. The patent owner sued Cunard. Got an injunction, they weren't infringers, to hold the goods until the true person was named and could be sued. A real example of the interesting thing that equity can do in inventing remedies in a way which I think is wholly unknown in continental Europe. No?
No, quite wrong. The Justice Arnold himself, in some of these references, referred to the German law on what we call Störerhaftung, that is the liability for persons who are not infringers but have an obligation and the possibility to avoid infringement being committed. So it's like a common law remedy. Also, on your transport issue, the case that I mentioned without giving an answer to is called in Germany MP3 player. It was an action for infringement against the shipper of infringing MP3 devices. And the court said he is an infringer and may be held liable. Now, not necessarily for damages unless he knew, because we have a rule which requires knowledge or negligence for damages, but certainly for handing over and destruction and all of these other realms. The shipper, these goods had come into Frankfurt airport by plane and were held up, and the patentee brought the case against the shipper. Possible, not only in England. 2011.
Very good. Well, at that point, I think we'll draw it to a close. Could you thank our speakers once again?
Thank you.